Welcome to our 7th annual Aphasia conference, Turning the Page on Aphasia. This is our third session, and this is really for you, your care partner, and professionals. This is a really special topic, and I was so happy to have this guest speaker present for us. Before we start, I would like to say a special thank you to Pam, Ken, and Kate for making this happen because, as you know, this is not done by one, it's done by a whole team. And without our sponsors, we don't have sponsors, but we have great support members and professionals. Dina from Rhode Island Wave, we couldn't thank her enough. She's really done an amazing job this year. And would like to thank URI and Risha to gather together to provide these CEUs for our speech pathologists in the Rhode Island OSHA organization. If you have more questions about that, you can contact Kate or Mary Jo. A little thing I'm trying to promote is that Saturday is Aphasia Awareness for the whole month of June, but to help contribute your part is to wear your gray t-shirt or an aphasia shirt today. This would be the one I'll be wearing all day. Let's everybody know about aphasia and educate others. As you know, this is a free nonprofit. This is a free organization. All the services we do in providing this conference, it continues to be free because I don't think that anyone with aphasia should have to pay to learn about a disability they did not sign up for. We also had our in-person group this month. We have one more session. That really did great. This is in Rhode Island, but all of those around the United States and more. We will be resuming our in-person group facilitated by Kate. So she's looking forward to seeing you all in July. But as usual, this is not, there still is fees that we have to continue to pay so that we can continue to do this free for all of you. If you could sponsor, donate, provide your time and resources, we would greatly appreciate it. Now I'm going to turn it over to Kate so she can give us a rundown of today. Thank you, Kate.
Thanks, Denise. I think you left your name out of there, however, but none of this was Denise's vision from the start many years ago. So we can thank her for all of us joining together this morning for this awesome talk. I'm going to introduce our guest speaker, and then I'll just go over the details for the CEUs/professional development hours. All right, so this morning, I hope you all have your coffee, your tea, or smoothies, whatever you drink in the morning, because Christine Diorsi Fitta is going to be our guest speaker today. She has been a practicing attorney since 1994. She is licensed to practice law before the courts of the state of Rhode Island and the Commonwealth of Massachusetts. She concentrates in providing individualized and personalized services in the areas of estate planning, probate, and guardianship with Sheen and Associates Law in its Rhode Island and Massachusetts offices. So Christine has a lot of awesome information to share with us today, but also, if any of you have questions about legal questions, estate planning, guardianship, anything like that, we do have an allotted time at the end of the session today to go over any questions you may have. So take full advantage of Christine and her expertise. If you have any comments or questions, you can type them into the chat throughout the presentation, or you can wait until the end and we'll do a Q&A. You can raise your hand and let us know, and we'll call on you. For any clinicians who are here with us today, if you are a RISHA or MISHA member, be on the lookout for the link dropped by Mary Jo in the chat. You will need to complete the link at the start, and you'll need to look out for the link at the very end of the session for CEUs. For all other SLPs who are not a RISHA or MISHA member, you are able to count this webinar series as personally tracked professional development hours. And all that you will need to do is keep an eye out for a PDF that I put at the end of the session during the Q&A in the chat. You can download that certificate of completion and use it to personally track your hours. Okay, that's enough for me. We're going to hand it over to Christine.
My name is Christine Diorsi Fitta, as Kate mentioned, and I am with the Law Office of Sheehan and Associates Law. I have to give this little kind of disclaimer at the beginning of my chat, and that is to say that the presentation that I'm providing today is educational only. I can't give specific legal advice to individuals, but of course I can answer questions and hypotheticals and that sort of thing. I concentrate in the area of estate planning, guardianships, probate, and these are topics or areas of the law that have a tendency to kind of meld into each other. Generally, what I do is I start out my discussions with respect to guardianships, and I work my way back to powers of attorney, estate planning, that is to say a will or a trust. And then I talk about how probate impacts all of the decisions that are made with regard to the estate planning, which is the will and the trust. So essentially what a lot of folks want to know about when I present to groups is what guardianship is, what it means, and what it does. Essentially, guardianship is the most restrictive form of control that can be placed upon any specific individual. So generally what the court is looking for is the court is really looking to see whether there are less restrictive means. A guardianship needs to take into consideration a medical picture of an individual. And that's really the first step. That's the first hurdle that needs to be jumped over. So essentially what would happen in a guardianship situation is before anything can be filed with the court or we can ask for the court's assistance, we need to go ahead and we need to contact the medical professional who is the primary medical provider. That particular individual needs to be a medical doctor, and that medical doctor needs to review different areas of a person's life and what types of limitations there might be, and also what type of kinds of assistance there needs to be in order for that person to be taken care of, if their affairs taken care of. And the guardianship can be a full guardianship, which means that the guardian essentially has the authority to make decisions for that individual for all areas of that person's life. So that would be where the person lives, who they communicate with, and who they associate with. It can be financial and it can be medical. You take a look at all of those particular areas, and the doctor really makes a determination based upon the medical picture as to exactly what is needed and exactly what the limitations are. Some doctors are quite specific. They talk about treatment. They talk about the type of treatment that they're providing, and they talk about, various other aspects of the person's life, such as the support from family members, support from perhaps a residential community in which they are living, and so on and so forth. Other doctors are a little bit more focused on, okay, this is the person's medical condition or diagnoses. These are the limitations that particular diagnoses pose. And these are the things that the person needs assistance with. And it's essentially just a very, short explanation. I always think that the more information that a doctor can provide, the better. The doctor would be looking at what we call a DMAT. And that's basically a form that a doctor fills out. And that particular form covers various different areas of a person's life and asks the doctor for specific information. The next hurdle after that is filled out and we have a doctor saying, okay, this is what needs to happen and these are the supports that this particular person needs, is a threshold question as to whether there are less restrictive measures. If there are not less restrictive measures, which would be powers of attorney and a healthcare proxy, then the court would entertain a petition for guardianship. As I referenced at the very beginning of my comments, a guardianship can either be a full guardianship that encompasses all areas of the person's life, or the guardianship can be a limited guardianship where, the doctor takes a look at various areas of the person's life that I referenced before, and the doctor feels that although the person needs assistance in making medical decisions or financial decisions, they really do not need to have any kind of assistance as far as where they live or who they associate with. And that would be a more limited guardianship. And guardianships are usually done when the person can't assent to a healthcare proxy or a power of attorney. So it would be a situation where the person can't make that decision for themselves as to whether they want to appoint an agent for healthcare proxy / power of attorney and financial power of attorney. So in the event that the person cannot do that, then we move to the court and we essentially file a petition with the doctor's opinions, and we ask the court to make a determination as to whether a guardianship is appropriate. And it's the court's job to satisfy itself that this is the least restrictive measure that can be taken in order to safeguard a person's well-being and to make decisions on their behalf. So the court will generally appoint an attorney or perhaps another individual, but they're usually attorneys who can make a determination for the court, or not so much a determination, render an opinion for the court. That person, who the court terms a guardian ad litem, has a limited purpose. That particular individual generally goes out to the individual's home, care facility, or what have you, and meets with that individual directly. Sometimes family members participate in the discussion in the event that the person does need someone else to assist them in communicating information to the guardian ad litem. Sometimes not. Sometimes family members are not included, and it really is a choice of the guardian ad litem as well as the individuals who are taking part in this process. So essentially what happens at that meeting is the guardian ad litem sits down with the person and talks about things like their living situation, what they feel they need assistance with, whether they feel that a healthcare proxy or power of attorney, durable power of attorney is appropriate, and it's something that they can feel comfortable with in terms of giving someone the authority that they need over various areas of that person's life, and that's all that's needed. In the event that the person objects to a guardianship and the person says, I'm perfectly fine to make a decision for myself as to who to appoint for agents. And at this particular time, I don't feel that I need a guardianship. Or on the flip side, yes, I do feel that I need a guardianship. And I don't feel capable of appointing an agent and knowingly entering into essentially what's an agreement between the agent and the individual as to the authority that individual will have in terms of decision making. So once that threshold is reached, then what happens is the court makes a determination. The court reviews all of the documentation presented, including the report of the guardian ad litem. The guardian ad litem, the individual for whom a guardianship is being proposed is present. The proposed guardian is present. And generally an attorney is present as well to present the case to the court and to answer the court's questions with respect to the legal ramifications of the guardianship and the communications that the attorney has had with the individual who is either proposing the guardianship or alternately the person that's representing the person for whom guardianship is sought. I see Denise has her hand raised.
I have a question. When you get together and you have whoever's your power of attorney, and it's hard with aphasia, when somebody may say, I want to be her power of attorney or his power of attorney, how much choice do I, with somebody with whatever, I need a power of attorney, do they do an interview behind just me and that person, or do they do it with that person right with me? Because I would think that if I was not comfortable with it, maybe my friend, my mother, my uncle, and I don't want them to be the power of attorney, but they're the ones that brought me here and we're making these decisions, it may be uncomfortable to be honest what I want. How do I get my message said without hurting somebody's feeling or being protected?
So essentially what would happen in a situation with respect to powers of attorney opposed to guardianship, with respect to guardianship, generally what happens is you are the person, you are not the person that makes that decision. It's actually the person who seeks to be your guardian that comes forward and essentially indicates that, yes, I feel this person needs a guardian, and I am going to ask the court to appoint me to be the guardian or someone else to be the guardian. So essentially that decision is made by someone else who's saying, I think that this individual needs a guardian, and I'm going to ask the court to appoint someone, whether it's me or someone else that I've chosen. Now, with respect to powers of attorney, you make the decision with respect to powers of attorney. So that kind of brings us to the next topic, where we talk about powers of attorney and we talk about who essentially drives the bus as far as that's concerned. The answer to that is you drive the bus. With respect to powers of attorney, it's essentially asking someone else of your choosing, to step into your shoes in the event that you cannot make decisions for yourself. A power of attorney does not necessarily become operative just because you have it, and just because an attorney or you have drafted a power of attorney for yourself. That particular document becomes operative when you feel that you need someone to make decisions for you, or when someone else indicates that you cannot make decisions for yourself, generally a medical practitioner. So the way that a power of or powers of attorney would work is this way. There are two types of power of attorney. The first one is healthcare. The second one is for financial affairs and just the business of your life, paying bills, writing checks for you, making financial decisions on your behalf, that kind of thing. And a power of attorney's authority can be limited, or an agent for power of attorney's authority can be limited. And it can be limited in a number of ways, or the power of attorney can have essentially all decision-making power and all authority over paying bills and communicating with individuals. So it can look like this. Why don't we do the power of attorney for healthcare first? That actually is my favorite document for estate planning purposes. And the reason I like that document the best is that it is the least restrictive means in order for you to obtain assistance with respect to healthcare decisions. It's also the least restrictive measure for someone to be able to communicate with your doctor or be present at an appointment with the doctor, speak with the doctor, have your questions answered, or have someone else ask the questions that are not questions that you've thought of or that you can communicate to the doctor. Denise?
Yeah, I just want to remind people, we are recording this. If anything that you ask now during this presentation will be recorded and everybody will have access to it. I do see people raising their hand and have a question right now about this topic. If you're okay to answer it now, keep raising your hand and we will ask Christine to answer it.
Oh, okay, that's fine. I didn't see people raising their hands. I'm sorry, but I do see a question here.
Okay. That's okay. Let's start with Mick Fitz had his hand up, or his or her, for a bit, and they typed in the chat, can you talk about the cost of guardianship? Are there any low/no cost options? And then Christine, we're going to jump over to you after. Christine Woodbridge.
Okay, so with regard to cost of guardianship, essentially the cost of guardianship is pretty reasonable. The cost of guardianship is limited to an attorney drafting a petition and appearing before the court and communicating with individuals. So I don't like to give a specific number because we have folks from different states, and I don't know the costs associated with each of the states from which you all come from. I can say that in Rhode Island, a guardianship is generally well under $3,000. And essentially, as I said, what you're paying for is the attorney to facilitate and bring together any individuals that need to be brought together. So that would be guardian ad litem, medical providers, and the court. So they essentially prepare the petition. They would go ahead and contact the guardian ad litem. They would also review the medical documentation provided by any medical practitioner, and they would file the petition with the court. most courts have a fee for guardianship. However, there are instances where the court will waive the fee, at least in Rhode Island and Massachusetts, based upon financial hardship. Now, with respect to no-cost options, most bar associations have some sort of a program whereby lawyers volunteer their expertise in a particular area. So I would suggest that you contact your state bar association and you speak with an individual there. I have found at least that bar associations and the staff that facilitate everything in that regard are very, very helpful. Essentially, what they will do is they will put out a blanket email to the members of their association asking for someone to step forward to volunteer to handle your case for you. The only cost that you will likely incur might be the costs of getting the matter before the court and the court fee. However, the attorney that's been appointed to you will be able to facilitate that as well, and will be able to file a document or some sort of a request to the court to ask the court to waive those fees. So that speaks to costs of guardianship. And it can vary from state to state. It can vary from jurisdiction to jurisdiction. So in Massachusetts, the jurisdictions are divided into counties. In Rhode Island, the jurisdictions for the probate court, and the probate court is the court that would handle guardianships, essentially is broken down into each particular town. Every town has its own probate court, and that is a court that has jurisdiction, and that is governed by the town in which you are living. So if you're living in Barrington, Rhode Island, like I do, a guardianship would be handled by the Barrington probate court. So essentially that those are the nuts and bolts of costs of guardianship and how to obtain at least assistance in finding an attorney that may be willing to handle your case for free or at a very reduced cost. Another resource would be the legal aid, or it could be called different things in different towns. In Rhode Island, it's called legal aid. And legal aid is an organization that is a nonprofit. That organization can be contacted, and if you meet the parameters financially of an individual who would need assistance or would need free legal advice, you will be accepted and they will appoint an attorney for you. They generally have attorneys that work on staff, opposed to a bar association where they're asking attorneys in the legal community in your state to step forward to volunteer his or her services. And yes, C. Wood, let me see.
Yeah, Christine. Go ahead. Sorry, her name is also Christine.
Oh, okay. Christine Wood, you had your hand up. You're muted.
Yeah, I'm the real Wood. I'm Christine's mom. And
Hi.
I was curious. Hi. I was curious as to the question that Denise had. So if I understand it correctly, somebody can just come and say, this person needs a guardian, and give their version of why they think the person needs a guardian. Now, with brain injury, sometimes people may appear that they need somebody, but they really don't. So who makes that determination if this person just say has a problem with aphasia, but otherwise they are okay?
Okay.
The attorney makes that determination, or who makes that determination? Would there be an option to call in a witness or somebody who's known the person all their life other than the person that wants to have the guardianship?
So essentially, the way that that works is that when the person who is seeking guardianship over someone steps forward and says, I think that this person needs a guardian, and I would like to be that guardian. Is there essentially they're the ones that need to jump through the hoops as far as proving that that person does need a guardian. So you have a safeguard with respect to what medical providers will say. You also have the additional safeguard after that determination is made of the guardian ad litem who steps forward to be sure that that person really and truly does need a guardian.
So who checks for the evidence, so to speak, evidence? I mean, that sounds kind of critical, but who checks that they actually did consult the doctors and the caregivers or whatever? Who?
Essentially, what happens is the doctor will need to write a report. And in that report, the doctor will need to provide information concerning that person's medical condition and that person's need for a guardian. So essentially, what happens is a form would need to be filled out before a probate court would even accept the case and assign it to a judge. So it's called a DMAT or a diagnostic. It's a diagnostic tool that or discussion that the doctor has with the court, and it's in writing. And essentially, that doctor would meet with a person or review all of the medical charts, all of the medical opinions that have been provided in the past. And that person would be specifically looking at what's going on with that person presently and what has been going on in the 6 months prior to the doctor seeing that person. Because the DMAT speaks to that 6-month period, because guardianships can be fluid. Just because someone needs a guardian during one particular period of their life does not mean that it's permanent. And it doesn't mean that that person needs a guardian forever. And essentially what happens in that regard is that the court, in the event that a guardianship is appointed by the court, or a guardian is appointed by the court, that person needs to step forward on a yearly basis and discuss what they have done for that individual, what changes have been made with respect to medical or any life changes that have occurred or been made for that individual, and whether guardianship is still appropriate at that point. And the court oversees that, and the court will review all of the information that is provided. The court will ask the guardian to step forward and discuss what's been going on with the judge, him or herself. And essentially, the judge will make a determination as to whether guardianship remains appropriate, whether decisions have been made appropriately, whether from a financial standpoint or a medical standpoint, and whether that person has had improvement in a specific area. So maybe that person was having a difficult time making decisions initially. However, since that person has been getting treatment and may have had an improvement of a certain area of his or her life, such as the ability to make decisions financially, that piece of the puzzle would drop off in terms of guardianship. And the court would say, although that person still needs assistance communicating with a medical provider to get adequate medical care, they really don't need assistance or a guardian over their financial situation. They now can live alone. They can live independently, but they still need assistance in some regards. The court may choose to keep the guardianship in place, or the court may say a guardianship isn't needed since this person can make decisions for him or herself. I think it's more appropriate for that person's guardianship to end, but that powers of attorney need to be in place in order to assist the person. Did that?
So I think my concern is more at the onset when it first starts. So say somebody I'm an older person, so it could happen to me. Somebody says, well, she needs a guardian. And I went to Dr. So-and-so and he filled out the form and everything looks cool. That's that doctor. I might have 3 other doctors who would not agree, but then I don't have an option to say, now, wait a minute. I want my other doctors to have input in this.
You definitely have that ability. So essentially the way that the probate process works is that the individual over whom guardianship is sought can be at the court hearing. It's encouraged that they are at the court hearing unless there are medical considerations or reasons why they cannot be there. The judge will ask the person directly whether they think that guardianship is in their best interest, whether they understand what is going on. And at that point, that person can present any kind of evidence that they want to the court to say, here are my doctors. I would like the court to look at these because I don't think I need a guardian. And a person can do that if there are issues with clearly communicating to the court. A person can do that in writing. They can come to court. They can have some sort of a written argument, and they can present that to the court. And the court will listen to that. They can have
an attorney for that matter. I'm sorry. They can get an attorney and have the attorney represent them.
Absolutely. Most attorneys will contact the doctors directly. I make it a practice to contact not only the doctor, but the guardian ad litem directly. I speak with the individual who is seeking guardianship over the person. And I've been practicing for a long time now. It's been over 30 years. So I can't say that, I'm always 100% on the mark, but I have a good sense of, situations where someone comes in and that person is just trying to control another person, or that person even really does feel that the person needs a guardian. That person actually is really kind of overstepping, not in a malicious way, but in an overprotective way. I also ask that the person over whom guardianship is sought be brought to my office so that I can communicate with that person. And I had a stroke myself many years ago, and I had issues. I had cognitive issues at the time. I had issues making my own decisions. I was very fortunate. I was very lucky, and I recovered from that. But I'm pretty good at being able to sit down with someone and really kind of ask questions of that person to determine whether that person feels that they're being forced into a situation, and to speak with medical providers to get their intake and input. I also like to meet with other family members if other family members are available and willing to speak with me. And I will ask questions about what they think about the relationship between the person seeking guardianship is with the individual over whom guardianship is sought. So there are a number of safeguards. I act as the attorney. I act as the gatekeeper of information and what gets provided to the court, the gatekeeper in terms of actually protecting the person over whom guardianship is sought. I take that responsibility very, very seriously, because I know that there are situations where people who are very well-meaning can really be overstepping and really not understanding that even though a person may not communicate the way that they did before, it doesn't mean that they can't make decisions for themselves. So, and did that answer your question? You're muted.
I'm sorry. Yes, yes.
Yeah, and I think the next one you're doing, I think is going to clear up a lot more, because there's two different pieces that you're going to talk more about now. Sometimes those two topics are confusing, but I think the next section will be great to kind of clear up some of the other questions people are asking.
Christine, before you dive in, Savan has a question real quick. Her hand raised.
I was just going to ask Savan to step up, because I see that your hand has been patiently raised.
That's okay. I just was curious. This goes on Miss Wood's comment about sometimes, obviously, everybody attending here has some sort of speech language cognitive deficit. So, as a speech language pathologist, are we able to be included, either our documentation or in person, helping with this guardianship, so we can help explain what aphasia is or what a speech language disorder is, that they may just be having difficulty communicating, but they can cognitively understand what you're saying?
Absolutely. So I always encourage any medical provider or practitioner to step forward, and I will specifically ask if there are other medical providers or to step forward and actually give their opinion based upon their expertise, based upon their communications or treatment of that person. To please give me an opinion. I ask for that. I welcome that, and I present that to the court. So essentially, the DMAT that's provided to the court might be a DMAT that is provided, would be a document provided by a medical doctor. I always welcome any other practitioners who can step up and fill in all of the blanks and fill in any questions that there may be that a doctor has not addressed. So essentially, the way that would look is that person can come to court, and that person can come to court at the request of the person over whom guardianship is sought. Sometimes I ask that the person come to court with us, because it's my obligation, really, even though the person who is seeking guardianship may have approached me and may have hired me. It's really my obligation to provide the court with the full picture. I can't cherry pick what is provided to the court. That's just not something I'm willing to do. We, as attorneys, we have an ethical obligation, and we owe a duty to the court, a duty of candor to the court. And a duty of candor to the court means that we need to provide the court with all of the information so a fair and equitable determination can be made, and a legal determination can be made based upon statutory law, in case law, and any other law that might be out there. And guardianships are guided by state law, but they're also guided by essentially a universal code or a universal act that speaks to guardianships and what is needed for guardianships, basically anywhere that you may be, and at least in the United States. And we have reciprocity with certain countries. And they have reciprocity, obviously, with us. That so it would apply if the person moved to another state. It would apply if a person moved to another jurisdiction or country. If that country has reciprocity with us, you would need to consult an attorney once you get to that place to make sure that you've met all the state requirements, but at least that guardianship will remain in place. And generally what happens is that there are documents that need to be presented to the court. Say, I had one very similar. A sister lived in Massachusetts, nearby Massachusetts. The brother lived in Rhode Island. The sister wanted the brother to move into her home. He was moving, and she had an addition built for him. So now the person is no longer in Rhode Island and subject to the probate court it was Bristol, Rhode Island, this particular case. The court doesn't have jurisdiction over that person, but Massachusetts would. So what would happen is what we needed to do is we needed to change the Rhode Island guardianship and essentially transfer it to Massachusetts. There are legal means to do so, that are fairly easy. The Rhode Island guardianship remained in place until Massachusetts stepped in and that whole process was taken care of. But all of that kind of veered a little bit away from what we were talking about, but it's important information to consider. But I do include other practitioners. I include as many people as I can when presenting information to the court.
I do think you're, like you said, you did have a brain injury, so you're very knowledgeable and have the insight to realize the deficits that somebody might have after that. But I also think it's important for the members who might not realize that they can sounds like they can if they can advocate to say, can you please include my speech language pathologist, my doctor, whoever you feel can paint that picture. It's important for the clients out there to know that they can advocate for themselves. If your lawyer, because not everybody might know that you're seeing a speech language pathologist or that you might need that. So I think it's important for family members and clients to know they can advocate, and that is completely within their rights to do that. If your lawyer may not know that, is that correct?
Correct, but I think that the vast majority of attorneys who do this kind of work
True.
understand that guardianship isn't based upon a snapshot in time and based on one person's opinion. Guardianship is a very it's an extreme measure. The courts know that it's the most restrictive. It's the most restrictive control that you can have over someone else's life. And I have not met an attorney who doesn't understand that and doesn't understand that they need to be the fact finder. They need to be able to, they need to ask the questions. And most attorneys, if not all of the attorneys that I've met who practice in this area, know enough to ask in those initial discussions with clients. Well, who else does Mary treat with? Who else does Mary see? Do they see a speech pathologist? Do they see a psychiatrist or a psychologist? Where are those reports? What are the doctors' names? And I contact the doctors myself, and I have the doctor send the reports to me so that I'm getting the doctor's words and not someone else's recollection of what a doctor or a practitioner may have had to say at some point in time. And the court will ask those questions too. The court doesn't want to appoint guardians. Attorneys don't want to have to ask the court to appoint guardians. We all know and we all appreciate the fact that we're asking the courts to take someone's autonomy away. We're asking the court to really essentially take every single decision making power away from someone. And that's pretty powerful. I mean, it's the most powerful thing that can happen. I know that when I had my stroke, I was fortunate because my husband came to all of the appointments with me. If I was having difficulty communicating, he would communicate with individuals. Guardianship wasn't a blip on my radar because I didn't need someone to step up to that degree, and he didn't feel that he needed to do so. But there are people who not so much panic, because panic makes it seem like it's unjustified, but who really and truly think that that person cannot make decisions for themselves because they see a person who is no longer the person that they knew. And they're concerned. Their main concern usually is that someone else can take advantage of them and they want to protect them. So my job, the job of the court, the job of medical practitioners, the job of medical doctors is to substitute their judgment for the individual who was really just trying to protect the person that they love and that they care about. And we're trying to assist in that and to discuss different ways that a person can be, or their interests can be safeguarded without without any kind of guardianship being in place, whether it's limited or a full guardianship. I hope that answered.
What about the attorney,
Oh, the guardian ad litem?
No, it's the attorney of, oh no.
That's okay. Take your time.
The, wait. Power of an attorney.
How to elect an attorney?
The power of, yeah.
Oh, okay. Okay, so that's the next topic. And I see one more question. And then Trish, I'm going to get to that next. And just really in a couple of minutes. And we're going to talk about that for a period of time. But I see here that Brian, oh, I see a lot of questions actually. Why don't I do the guardianship questions first? Then I'll start on the powers of attorney, and then I'll open it up to discussion. So,
and Christine, I think the ones in the chat you covered, we read out loud. The next section, the last one was Michael asking about Brian Bassett. I think he's wondering about a rating, if it's a good attorney or not. And then I think we can go ahead and dive into power of attorney, because the other, Maureen's question kind of talks about that too.
Well, I asked Brian because Brian was a lawyer at Robes and Gray before he had a stroke, but I was just curious what he's thinking right now. Brian Bassett. So yeah, it's great. Thank you.
Okay. So is there a question pending for me still?
I think it's the one that I see at least says, can you explain powers of attorney to be currently effective versus effective upon incapacity. And
Okay.
Trish, I don't know if you were asking a specific or kind of like general information about power of attorney.
Go in.
Okay. You want us
Dive
to go?
in.
Okay, dive in. I will dive in. I just want to be sure, Brian, the question is answered. Brian Bassett, is someone asking if Brian Bassett is a good attorney? Was that the question?
I think so. I think, Michael, did you say he also had a stroke or something?
Yes, Brian Bassett works with a Aphasia Resource Center at Boston University. He's a very
Mhm,
kind, very thoughtful. Went to Amherst, and he's great. I mean, he at Robes and Gray, a great place.
mhm.
Had a stroke. He does it now. He's very interested in it. I was just curious what he thought because Robes and Gray is a very prestigious lawyer outside in Boston. I was just curious what he was thinking because we're thinking about a lawyer right about now. Um, it's a very interesting idea because we're dealing with people with an attorney. I'm blessed. I'm very, very blessed. Very, very blessed. My wife is at Rhode Island College, and she's been watching my wife very closely, very well. But I'm sure that I already have an attorney. I already have all the people for this, Ameriprise, financial. I have all the people, right people for this. So I don't even think about it. But yeah, if I don't belong with someone in stroke or I'm not with anyone now, I'd be frightened if I have an attorney. I'd be very afraid right now for an attorney. So yes, I was just wondering if Brian Bassett was saying anything. So I'll stop right there. I'll yield right there.
Okay. Ropes and Gray is a great law firm. I don't happen to know attorneys from Ropes and Gray that are currently working there. All I can say is I know that it has Ropes and Gray has a great reputation, and I don't know if they have. I don't know if they have a department, guardianship department or specialty or I know in Rhode Island we can't say specialty, we have to say area of concentration. So I don't know if there are any attorneys here that specialize or concentrate in the area of guardianship. So I couldn't really make any kind of specific recommendations regarding attorneys, but there are ways to search for aphasia knowledgeable attorneys. Um, I don't know the answer to that question, Michelle. Um, I really don't. I think that it's kind of a situation where with attorneys, just like anyone else, any other provider that you go to that provides professional services, it's someone that you would need to vet and you would need to speak with to see if that person is actually a good fit for you. Um, what I think can be done is that attorney can be interviewed just like an attorney interviews you for information. You can interview that attorney. When you initially speak with an attorney, that attorney is essentially going through a job interview with you. And no one should feel uncomfortable about asking attorneys what their knowledge base is in terms of any area that falls outside the law. Really, the whole point of obtaining an attorney is the person that's going to be able to represent your interests before the court. And if you don't feel that that person has an adequate knowledge base and you're not comfortable, then I think that you may want to speak with someone else. Now, I can say that just because an attorney does not have a lot of experience dealing with individuals with aphasia, it doesn't mean that that attorney isn't qualified and will not do a great job on your behalf. I think that we're asked to step into a lot of different situations and represent a lot of people who come from different walks of life, who have, their own unique medical profile or legal situation. And we might not have all of the information at our fingertips, but as attorneys, if we take on a case, we must make ourselves knowledgeable in a specific area of the law or a specific, with respect to a specific topic. I know that when a client comes to me and asks me to represent them, I make it my business to learn about that client. I take a lot of time in my initial consultations with clients, really getting to know them and what they need from me. And if that means that someone, comes to me with a unique set of circumstances or presents me with facts, I make it my business to be knowledgeable on that topic. That's just me, but I think that's just about any attorney you would encounter. We know, attorneys know the relative power we hold in our hands with respect to our clients. And I really don't know of any attorneys that don't take that very, very seriously. We know that we are representing someone and we are doing something for someone that's extremely important for them into their life, maybe the direction of their life, or the direction really of their everyday life in situations like guardianship. And we take it seriously to the point that some of us, or most of us, are probably go overboard trying to make sure that we are providing our clients with everything we have and everything that we bring to the table. And if we don't have that, we seek out the information. I very commonly work with other professionals, whether, when I do probate, I work with accountants, I work with financial advisors, because I don't practice in those areas. I'm not a financial advisor and I'm not an accountant, but I know that I need to pull in other individuals where there's a complicated tax question with respect to a trust or estate. So it's very common for attorneys to pull in other people who specialize in a completely different area to make sure that we have the knowledge base that we need. It looks like there may be some.
I would like to say hi to Brian is here. Michael was referencing Brian in our group. He is here, so thank you for attending.
Hi, Brian. How are you? Okay, so the other comments are really comments and not questions directed to me. Does anybody else have any other questions regarding guardianship?
Well, I looked at, I used to Google with aphasia and stroke in Rhode Island, and I received a letter from Rhode Island with a list of about 10, 12 different Rhode Island, just with stroke, aphasia. And I guess if I went in and meet that person, I'd ask them, I said, I had a stroke 9 years ago, I have aphasia. Would you be helpful or not? And that's how you can find out if you liked them, you can stay with them, or if you didn't like them, go for other people. But he's got 9 or 10 people. I mean, to meet each person, it probably take a long time to do this right, but just go look for the person you want to find right now and find about the financials and all those ideas about the berry or whatever you used at the death, a person about this, the properties with this. So that's one way to do is just go on one to one person, I think.
That's one method that definitely is. There also the state bar associations may be able to assist as well, to provide information. They won't, most bar associations are not going to say, okay, I'm going to recommend this specific attorney, but they may be able to point you in the right direction as far as finding an attorney. Plus, you'll see a lot of attorneys will have either, you can do a general search, guardianship attorneys in Rhode Island, and people's names will pop up. It's not the best method to find an attorney, but when you're doing your initial research on attorneys, I think that it's a starting point if you can't find another source to provide information.
Thank you.
Okay. So why don't we, since it's 10:15 now, why don't we move into powers of attorney? And then if there are any questions that people have regarding guardianship, they can come on back to that. So powers of attorney work like this. A power of attorney is the person's choice as to whom they're going to ask to step forward to act as their agent for power of attorney or their proxy. In Rhode Island, we call them agents. In Massachusetts, I know they call them a healthcare proxy. So in Rhode Island, at least, there are two different types of power of attorney. The first power of attorney that I usually speak about is the healthcare power of attorney. The healthcare power of attorney is just that. It speaks to decisions with respect to healthcare decisions. It speaks to the involvement that your agent that you have appointed and chosen has with respect to your healthcare and your healthcare decisions. And it's a document that most people use when, I see it a lot when people are in nursing homes, or I see it a lot with people that have the need for some sort of assistance from someone. And it usually looks like this. At various points in time in a person's life, they may have issues obtaining services, medical services that they need, or they may need assistance in making those decisions. In speaking with people, in obtaining information, in really just sitting down with them and saying, okay, we went to the doctors, I went with you, what do you think? And the person might say, I just can't make a decision today. I can't make a decision tomorrow. I don't know when I'll be able to make a decision. It may be a medical question that is, you need to get the answer to the doctor and make a decision on immediately. In that case, essentially, your power of attorney for healthcare can step up to the plate and make that decision for you. Power of attorney can also come into play when you do not have the power to make or the ability to make medical decisions for yourself at all. So it can look like this. A medical doctor is basically determined that although you have other decision-making power with respect to finances or some other area of your life, you just, for whatever reason, cannot and are not capable of making a decision with respect to your health care. In that case, your power of attorney would become operative, and that person who you have appointed, who you have a trust level with, will be able to essentially step into your shoes and make a decision for you. Most people will come to me within the parameters of estate planning, but I have had people come to me seeking power of attorney for situations such as the one that I found myself in after I had my stroke, or that any individual might find themselves in after they've had a stroke or after some sort of a medical incident or episode. So people come to me, they have to have the requisite capability to make a decision that they want to appoint someone as their healthcare power of attorney. So we generally ask individuals, okay, you'd like us to draft a power of attorney for you. And we know that you have one agent that you would like, and that would be the primary person that would ideally be able to accept the responsibility of making decisions for you. But what would happen if that person were not available? Say a medical decision needed to be made. You are in a rescue squad after, an accident or something like that. And a doctor needs to immediately make a determination as to what kinds of treatment to render. The healthcare, and you have a healthcare power of attorney, and you've provided that to your primary care physician. And your primary care physician has communicated that to the hospital. The hospital will contact the person that you have referenced as your power of attorney. And that person might be available, or that person might be overseas and they can't be reached. That person, may be in the military and they've been deployed and they can't be reached. So it's important for you when you're making a determination as to who to appoint as your agent, to essentially say, okay, I need two other people that I trust to make decisions for me, who will accept that responsibility and who I feel completely and totally comfortable with, because you're talking about obviously your body, you're talking about medical treatment that can be rendered, or any other type of treatment that can be rendered from a healthcare perspective. And you're asking them to essentially make decisions that can affect your life on a day-to-day basis. So a lot of times what people will do is they will ask for a power of attorney, but they ask to have their spouse or significant other or another contemporary appointed as the agent. That's perfectly fine. Sometimes they choose a parent. That's perfectly fine. But I like to encourage my clients to keep in mind that that person may predecease you in the event that, any age group, agent that you choose, no matter what age they are, they could predecease you. But an individual who's your contemporary is more, probably more likely that person, as you get older, may predecease you or may not be able to provide the requisite decision-making power that you need in order to safeguard your health. So I also encourage people to choose maybe their adult child as a second, or a niece or a nephew, or some other individual, perhaps a little bit, of a different age differential, a sister or brother who may be younger, someone like that, so that throughout your life, as life events change and as people unfortunately pass away, you have someone else to fill those shoes, because you don't want to be in a situation where you have a power of attorney, but you don't have an agent who is available. So essentially what would happen if that were the situation, you chose one person, that person predeceased you, then the medical practitioners are going to substitute their judgment because you're not able to make decisions for yourself. And I'm not saying that a medical care practitioner would necessarily not acting in your best interest, because they would, but it might not be what you want. It may be a situation where you're on life support and you never really wanted to be on life support, or you only wanted to be on life support, for the extent of time it takes a doctor to make a determination that you're only alive because of life support, and that's not what you want. You really do not want to live that way, and it's your wish for that not to happen. If there's no agent for power of attorney, the doctor is, as I said, is going to substitute his or her judgment in most cases. So essentially, I I would choose people of various ages in order to act as your agent for power of attorney. Now, power of attorney for healthcare can be quite specific. Some states allow or they recognize a document called the Five Wishes, which is extremely specific as to what is needed in your mind to as far as a medical emergency. So the Five Wishes is recognized by the state of Rhode Island. It is not recognized in Massachusetts. So a power of attorney can incorporate the Five Wishes that speaks to, I would like to be kept alive if, and it gives a number of different scenarios. There's a space for you to write your own wishes. It talks about funeral arrangements. It talks about how you would like to be cared for, whether you would like to pass away at home or whether you would like to pass away in a hospital setting or what have you. If the state that you're in does not recognize the Five Wishes, that can all be included in your power of attorney for healthcare. And it can be very specific, as I indicated, and encompass any kind of situation that you can think of. In the event that you do choose to have a power of attorney drafted for you, I always recommend that you provide one to your doctor, your primary care physician, or any specialist with whom you treat, as well as the agent for power of attorney, so that they have that document at the ready in case they are called to a hospital or they are called to make an immediate decision. They will understand what powers they have. They will be able to take that document with them to a medical doctor or to a care facility so that they can show that, yes, I am the one that does have the power to make these decisions. I can stand in this, I can legally stand in the shoes of your patient and make these determinations. So that's a power of attorney for healthcare. And as I said, that's, with guardianships, it's a fluid document. You can make a decision at any time in your life to change your agent. Contact your attorney and say, I've had a change of heart. I would like to change the agent for power of attorney. Life circumstances have changed or that person has passed away, and I would like the second person to step up, and I would like to appoint a third person. So it's something that can be done. It's not written in stone. Now, with respect to powers of attorney for healthcare, I kind of look at that document not just based upon the importance it has from a legal perspective and from the perspective of appointing someone to make medical decisions for you. I kind of look at that document as something that you can do for the individuals who would be your caretakers or who love you and want the best for you. I see it as a kindness to them, because it's a very hard thing for someone to make a determination with respect to someone else's physical, well-being. Obviously, it's also a very hard decision to make a determination that life support is not something that's going to happen, that life support needs to end. I think that it's a great kindness to the people that you are leaving to make these decisions, to have that healthcare power of attorney in place so that your wishes are known. It gives people a permission structure to follow what your wishes truly are, not what they would like to happen. It takes the as far as as far as possible, takes the emotions out of making these decisions on behalf of someone. I thought I heard someone. So that's why I like the power of attorney for healthcare. You can make it as specific as you'd like. You can make it as general as you'd like. You can make it specific to different, you can speak to different medical conditions you have, what you would like to happen, the types of decisions you would like made. And doctors will follow your directives when presented with those directives from your power of attorney. Along with the power of attorney, I always provide my clients with a HIPAA release so that they can make a determination as to who is going to be able to speak with doctors, obtain medical records, and that kind of thing. You would think that the power of attorney would be enough, and it probably is in some medical settings, but I've been finding over the years that, as HIPAA tightens up, and is HIPAA, I should say HIPAA regulations tighten up, the hospitals have, and medical practitioners have made their own decisions with regard to how they're going to proceed with, dispersing your medical information and who they're going to speak with. So I always do a HIPAA release on behalf of my clients so that they have that document too. Does anybody have any questions with respect to the healthcare power of attorney? Trish?
What about I'm living Florida and my sister is living New York. So is good?
That's a great question, and I get asked that question all the time. I don't necessarily see a huge problem with that. And you can certainly choose someone that lives in a different state. The only word of caution is that it may take a little bit longer for your agent if the hospital requires them to provide the power of attorney to them. It might take a little bit longer to get it to them. I had a situation fairly recently where, and this was a guardianship, but the hospital had the same policy for power of attorney. They wanted specific information faxed to them right away. And for whatever reason, the communication wasn't great between the healthcare provider or the hospital, I should say. And, go figure. And the person that had the guardianship. And by the time the hospital got its act together, the person had been discharged. I had to get involved in that situation to find out exactly what the hospital even wanted, because my client could not tell what the hospital wanted because one person told them one thing, another person told them something else. But by the time the right person got on the telephone with me and told me exactly what was needed and exactly whom I was supposed to send this information to, the person had been discharged. So that is a word of caution, although it can be done if that's a person that you're the most comfortable with. I would just encourage you to have, as I said, 3 individuals who you can rely on, and perhaps choose someone that lives in your state of residence that can step up to the plate in case there's a glitch like that. And, someone that needs to step up. Okay. And that's the same with the durable power of attorney for financial affairs. That's easier. That can be, someone from out of state. I've never had a situation, and, I'm sure that there have been situations that have arisen. I've just never been faced with a situation where, there's been any issue with getting documentation or what have you to the court. Yes, I see Jay has a question. Jay, did you raise your hand? Maybe not. Um, so,
That's okay. I see. Oh, sorry. There is a question from Christine and her mother again. Sorry.
okay.
I'm sorry, I'll make it really quick and it's short. If you don't
That's okay.
have a third okay, let's see, one, if you don't have a second and third person to speak for you in the event, if your primary physician has a copy of your healthcare power of attorney, he will be contacted, right? If there's nobody else. So then he could essentially say, this is the power of attorney, this is what she wanted.
I am sure that a doctor would provide that information, but if there's no agent to make those decisions and you're not able to speak for yourself, you're incapable of making those decisions, and there's just no agent there, then it would be up to the hospitals in the doctor's office's internal policies as to how they handle a situation like that. And as I said, each hospital can have its own policies and requirements. I've run into that a lot, particularly since a lot of the private doctors' offices have been gobbled up by these conglomerates like a Coastal Medical or you name it. There are a bunch of these large medical providers or businesses that kind of gobble up a whole bunch of offices, and they're all under the same corporate umbrella. So what would happen in that case is a doctor who may have had who would have followed all of your wishes essentially is not the person making the decision anymore, because his practice has been bought out by this corporation, and he has to, or she has to, act under the rules of that particular corporate entity.
So what if the hospital itself has a copy of your directive? Because
it's the same. It would be the same answer. Yeah.
All right. Thank you.
I mean, you would think that they would follow it, but I can't say for sure that they would.
Okay. Thank you.
Okay. Are there any other questions with respect to powers of attorney for healthcare? No? Okay, so we
sorry,
can
Christine, I think Kathy has one.
Oh, I'm sorry, Kathy.
That's
Kathy,
okay.
Kathy, do you have a question for me?
And Kathy, you're on mute.
You're on mute, Kathy. I can't hear you.
Okay. It's my son.
Hi, I'm Kathy's husband.
Hi.
She was wondering, do you need a power of attorney to stop recitation? Like if you don't want to be on, on tubes and whatever, do you actually need a power of attorney to do that? Or is there some form or whatever to fill out that would, like say me, for example?
Right.
If that's her wishes, do you actually need a power of an attorney?
Some hospitals have forms that they will allow you to fill out, or doctors' offices have some forms that they may allow you to fill out. However, I, specifically what I deal with are the powers of attorney. My wheelhouse is the wheelhouse for legal. I don't know what any specific doctor's office or hospital would have in place. Some of them, but as I said, some of them do. Some of them will give clients a HIPAA release and they'll give them a power of attorney. But if someone can't make a decision for themselves, I think it would be up to the medical care provider whether they're going to consider what a spouse or a child, has to say. I think that some of them would, but I don't think that all of them would.
Okay.
I think that some of them would just say, we need to follow the medical protocols, regardless of what you're saying she wants. You're not the agent for power of attorney. And I, legally cannot allow you to make decisions on this person's behalf.
I have a question about, like, we all have to fill out these portals now. So if these portals have all this information about whatever's going on, what meds we have, whatever that, but would our wishes be put in that portal? So like I say, I don't want to have, any, I want it to be like this. I can put all my desires and wishes in the portal, and would that be considered legal?
I don't know the answer to that. I think it would really depend again on the hospital or medical provider's policy, because it's not a true power of attorney. So, in other words, a true power of attorney is something that obviously it's a legal document, and it's obviously subject to review by a probate court. So in any event, I don't know the answer to that. I think that each practitioner will have, or each corporate entity will have its own rules and regulations. So they may follow it, but perhaps they won't. Okay. Any other questions?
Yes, I see another hand up. Oh, sorry. I see McFitz has their hand up.
Oh, okay, sure.
That's me again, Kate. Sorry. I wanted to just add my 2 cents about the healthcare agents.
Please clarify who you are. Can you please clarify your role and your background?
Oh, yes. Thank you, Denise. I'm Elaine, and I can't change why it says McFitz. I have some kind of technical problem. But I am on the board of Just Ask, and by training, I am a social worker, and I've spent 30 years working in hospitals. So my 2 cents in doing an advance directive is really be thoughtful about what you want and write it down. That is your absolute, I think, best option for making sure that your care in a hospital looks like what you want it to look like. You can write so much stuff in there. If you don't want to be intubated or have CPR again, Kathy, you just write it in there. And I mean, I don't know, 99 out of 100 times, your wishes are going to be absolutely honored to the T. So I would be specific. And if you want help with it, you can reach out to me at Just Ask, and I'll help anybody do them.
Thank you.
So thank you.
Thank you so much for providing that information. I'm not in the hospitals, and I don't really have communication directly with the hospitals unless I'm contacted. So that's great to know that that hospitals will follow that directive. I've heard it from both perspectives from clients, but you have the obviously expertise. You're in the hospitals in communicating with them on a regular basis. So I appreciate that.
I'm just going to interrupt. We are already almost at 10:45. We are really, that was a lot of information. We do have another person to wrap up our session today. So unfortunately, we're just going to ask Christine to kind of wrap it up quick, and then we will have a guest finishing up our session today from Michael.
Okay.
So, thank you.
So the other topic that I want to just discuss, and I'll do it very, very quickly, it's the same process as a power of attorney for healthcare, but it's a power of attorney for finances. Again, power of attorney for finances, you choose your agents and you choose what authority that person can have. Generally, power of attorney gives for durable power of attorney to make your financial decisions, has the authority to go ahead. They can contact financial institutions. They can sell your home. They can sell stocks, bonds. They can access your checking account. They can speak to billing departments. They can make payments for you. All of that can be, parameters can be set for all of those authorities, or some of those authorities can be deleted. And Kathy, did you have a question? You're muted. Hi, Kathy.
Yeah, my husband is here, and I had the phone the thing for the can't say it, the other one, the clothes and other things
Mhm.
is gonna be Perry. So I had to know the
So I guess she's asking, so she doesn't need, like, if you have a will set out. And
No, a will comes into effect after you pass away, but the power of attorney for finances and your business dealings, that is in effect during a person's lifetime.
okay,
So the will comes after, and the will talks about what happens to the property that you own
yeah.
after you pass away.
okay.
So
And
it's gonna be Barry because she has my help.
Well, I don't want you to see you die, so
You know,
that's
it's,
what.
my thing is Barry is my husband, so it yeah.
Press one.
so I think that what you're asking is that does the fact that he's your husband mean that he would automatically be able to do these things? And the answer to that question is not necessarily. Say you are the only account holder, or you have, or you go into a hospital, or you go to a doctor's office, or you have some stocks or bonds in your name, and you need to sell those off for, to pay for medical care or what have you. The fact that he's your husband doesn't automatically mean that those institutions or companies will speak to him and allow him to make a decision without the power of attorney.
Okay,
Yeah.
okay. Thank you.
Do it.
Perfect. Thank you, Kathy, for that question. And thank you again, Christine, for sharing all of your time and expertise and knowledge with us today, and personal experience. That's wonderful. We are going to have a special poem shared with us in just a moment. Before we do, I just wanted to remind everyone that we are posting the recordings of these sessions and the slides from these sessions on the Just Ask website. And it will take a little bit of time to get the recordings on, but we will we'll try to post like a summary kind of all the wonderful information and questions discussed here today within a few days, probably. So just give us some time for that. Maureen, yeah.
Kate, can I just ask Christine quickly the question that I initially asked, just for a quick response about if she could explain a power of attorney to be currently effective versus upon incapacity?
Sure. I have some individuals who have come to me for powers of attorney who will say to me, I don't want to make those decisions for myself anymore. Some people are perfectly able to make decisions for themselves, but they may be older and they just don't want to. At that point, whoever the power of attorney is has the authority to step forward and make those decisions. Or in the event that someone is incapacitated, then the power of attorney would come into play. Some powers of attorney specify that they only come into play in the event that a medical doctor determines that the person is incapable of making decisions for themselves. And that's something that can be added to the power of attorney.
Okay, thanks, Christine. And I'll put If it's okay with you, I know you shared that I can drop your email into the chat for anybody to reach out if they have any other additional questions or comments or want to float something your way. So I will do that in just a moment.
Okay.
I think for Risha and Misha members, keep an eye out for the link that Mary Jo will put in the chat. And for everyone else, I already put the certificate of completion in the chat and we'll do so again soon. But at this time, we're going to have Michael jump on and share a poem, and then we will close out our session for today.
Well, thank you, Kate, very much. And thank you, Denise, for this opportunity. I love working this from 7 years ago, 2019. It's wonderful. I also love Susie on here with a University of Florida for basketball. So I guess it's the game to see. It's not UNC, but University of Florida. Very nice job, 2025. And of course, I love seeing Marshall Yancey, who's every day in Facebook. He's always here. Marshall's a very nice man. Thank you very much. Um, about 10 days ago, I read Denzel Washington read the commencement to University of Pennsylvania, and he told about Fall Forward, and I was very inspired by Fall Forward. So I wrote this poem. I went to Overnight Might in Warren, Rhode Island. I read it on Friday, and I have to read it again. It's called Fall Forward. Good day, my friend. I'm here. Yes, aphasia. Walking through life, a struggle. Aphasia. Denzel Washington explains. Aphasia. Ah, yes, aphasia. A long, winding road. Living a strong, cursed life. Aphasia. Yes, sorry. Oh my goodness. I'm sorry.
You're okay, Michael.
Here it is. I'm sorry. I got a call. I'm sorry. Living a strong, cursed life. Aphasia. Yes, aphasia slips by the silent death. Is acquired by communication. Disorders that impairs a person's ability to process language. Yes, process language, but does not intelligent. Hear that? I can process, but I don't kill intelligence. Aphasia. This is the month of life, friend. I can speak intelligently, friend. Aphasia. I imagine life. No sound. Aphasia from Greek etymology. Aphani, not speak, translate aphasia. On 21 May 2016, I had a horrific ischemic stroke. Fall forward, tells commencement Denzel. Fall forward, says Denzel about failing. 1.7 GPA at Fordham. You'll fail some point. You fail, accept it. Leave, Denzel. You know, fall forward. You will struggle, have failures, lose journeys. You'll feel depression, angry, fall forward. But with my low star to my dear Carolyn, I'll make it. It's a journey. Fall forward. Stay awake, friends. Live life now. Fall forward. Mark Harder devised a new life. Talk slow. Mark creates a new year. Yes. Fall forward. Now, I cycled across America. Missoula to Revere Beach. Fall forward. Now, Pilates, yoga, bar. Fall forward. Now, poetry, piano. Fall forward. Here's life in a new everlasting. Here's what I've seen to be good and fitting. Live life and drink well because this is life. In every season, turn, turn, friend. Please don't hide the righteousness in my heart. You live, you learn, improving, yes, focus. Rick Ross says, every day I'm hustling. Thank you very much.
Wonderful. Thank you so much, Michael, for sharing that.
I had a Zoom. Somebody, I'm doing this a Zoom. Oh my God, a Zoom was that? But it's gone.
No, it was great. It was great. Thank you for taking time to share that with us today. And thanks everyone for joining us this morning. We have our last and final session next week. Next Saturday, we have a really cool triad speaking. It's Dr. Katie Strong, Bruce Farrell, and Coleman Watson. And their presentation is called Turning to a New Page with Aphasia, Finding Power in My Story. And so Dr. Strong led a really powerhouse panel last year during the conference, and I think we all loved it so much that we invited her to come back again with some new storytellers. And so
I hate to say, I hate to correct you, but she had such a great time with us. She contacted us and said, "Can I do it again?" So I said, "No problem. Come on back." And so I felt really honored that she invited herself to come back. So this is great.
The feeling was mutual. It sounds like awesome. So join us next Saturday for our last and final conference topic. And we hope that everybody has a great rest of your weekend. Thank you again, Christine, for joining us this morning.
Go get her, Susie.
Thank you. And thank you all of Aphasia friends that attend all the time. Thank you all for my board members that make this happen. And thank you for all the organizations that support Just Ask along the way to make this happen. And wish you all a great weekend. See you on Saturday.